Hi, welcome back to Securities Regulations. Now, so far we've covered the entire gamut of an initial public offering. And we spent quite a bit of time on this because I wanted to ensure that we were all on the same page with regard to what goes into a initial public offering. Now, you will have noticed that while there were a number of requirements in the IPO, there were a few requirements that are absolutely critical. First, there needs to be a shareholders resolution or some kind of authorization from existing shareholders. Second, there needs to be an offer document, a document that talks about the transaction, that talks about the company and gives the reader detailed information about the company so that potential investors may make a well-informed choice. The third requirement was that of the presence of merchant bankers or people who would ensure that whatever is being talked about or disclosed in the offer document is actually true. We'll see how these three requirements of authorization, disclosures, and merchant banks kind of repeat themselves from time to time. So, using the IPO as a base, let's move on to find out more about other forms of fundraising. We'll start with a private investment in public equity or a PIPE deal. Now, a PIPE deal is also known as a preferential issue in the SEBI ICDR regulations. Now, from regulation 160 in the ICDR, we find out how these PIPE deals can be done. Now, again, this is a private placement, not a public offering. What this means is that this offer cannot be made to more than 200 people in any financial year. Under Section 42 of the Companies Act, the Sahara Clause as we call it, you cannot, if you're offering shares to more than 200 people within a financial year, that is deemed to be a public offer and must come under SEBI's guidelines on public offerings. However, when we are talking about a preferential issue in an already listed company, you would still have to abide by Section 42. And in a preferential issue or a PIPE deal, you're basically offering shares to a small group of people instead of the wider public market. Now, this in itself has its own complications. For example, a small group of people may have a better idea about the company rather than the average layperson. In other words, a smaller group of people will be able to do a diligence on a company, whether listed or unlisted. Effectively, in a preferential issue, it is not unusual to see potential investors actually carrying out their own diligence on the company before they make up their minds as to whether or not they want to put in a sizable amount of investment in the company. Now, under private placement requirements, a company is required to issue what is known as a PAS4 form, which is the Prospectus and Allotment of Securities form, and to intimate the registrar of companies that the company has received a fresh inflow of funds against which shares or other securities have been issued. However, that is the end result of the private placement process. The private placement process, in a nutshell, is essentially one or a few investors getting into talks with the company and the management and the promoters of the company to see what kind of investment the company is looking for, what is the valuation of the company, what is the company going to do with that money. This is followed by a diligence, as I've mentioned before, and is followed by lengthy negotiations as to how this money will be transferred, what are the rights that this private investor will have, and so on and so forth. Now, as part of this entire process, a share purchase agreement or a share subscription agreement will be drawn up. In some cases, in a public listed company, a shareholders agreement may also be drawn up. For private companies, not listed companies, these shareholders agreements will have voluminous clauses as to how companies will behave with one another, how the shareholders will behave with one another. Of course, the terms of these these shareholder agreements must find their way into the articles of association of the company under the ruling of Rangaraj. Now, but that is a discussion for mergers and acquisitions, and we're really not concerned about it much in securities regulation. Suffice to say that it is possible for a small group of individuals or even one individual to invest in a company even when it is a listed one. So let's take a look at what goes into a private placement of shares in a publicly listed company. Now, obviously, the company will need a special resolution under 62(1)(c), and this resolution will effectively authorize the company to issue fresh shares to a private group of individuals, to a select group of individuals. Now, investors may put in the money but must have shares allotted to them within 15 days. And we'll come back to this 15-day problem later on as well. Now, this special resolution by shareholders must include a number of disclosures to the effect that they must disclose the objects of the issue, the maximum number of shares to be allotted, whether any of the promoters, directors, or key managerial personnel will subscribe to these shares, what is the time frame of this issue, the identity of the shareholders, including the ultimate beneficial ownership, right? All shares that are issued must be in demat form, and the issuer company must be in compliance with listing regulations. Now, when you have all of these things put together in the shareholders resolution, that is then passed, and now the private placement process can commence. Now, in a standard private placement process, the investor will typically do a diligence of the company, identify certain faults or risks that will have to be mitigated in the form of conditions precedent or subsequent, or representations and warranties backed by indemnity. However, this 15-day time period from the date of the shareholders resolution to the allotment of shares, this becomes slightly problematic, because once you have the shareholders resolution, then doing a diligence and drafting and negotiation of the offer documents along with conditions precedent being satisfied and closing becomes a bit problematic. So in the practical sense, all of this work is done prior to the shareholders resolution. So the shareholders resolution is literally the last step. In reality, it is literally the last step before shares are issued through a private placement in a publicly listed company, right? Now, there might be instances where this private placement may require some government approval. It might require approval from let's say the Competition Commission of India, depending upon the facts and circumstances of the case. It might require approval from any other government regulatory authority, right? So for example, it could be for telecom, it could be for automobiles, for pretty much anything under the sun. In which case, the 15-day time period is kept in abeyance. It's kept suspended until such time as the government or whatever authority gives its approval, right? So if the allotment is not completed within the stipulated 15-day time, then a fresh resolution has to be passed. Now, there is a reason for this. There's a reason for this 15-day time period within which I have to complete my private placement. I hope you understand that in a listed company, prices may change, may fluctuate on a day-to-day basis, right? Which means that over time, the price of these shares will change, which means that between the shareholders resolution and the allotment of shares, we should have as minimal a time as possible. Now, how is price calculated? Fairly simple. It is either the average of the weekly high and low for the past weekly high and low of the share price for the past 26 weeks, or the average of the weekly high and low for the average price over the last 2 weeks, whichever is higher. The idea behind this pricing strategy is that if you have a private investor who's coming in, they cannot be allowed to buy shares at less than market price. Doing so would mean we are violating one of the basic principles of capital markets regulation, which is all shareholders are created equal, retail shareholders are more equal, right? So the market price becomes the benchmark for the investor to buy shares or to subscribe to shares through this private placement, right? Once this private placement process has been completed and the investor has subscribed to these shares are locked in, right? These shares are locked in for a period of 1 year in case the investor is a non-promoter, but they're locked in for 3 years in case this investor is the promoter, right? So this has been about preferential allotment of shares in a publicly listed company, or also known as a private investment in public equity, or also known as a pipe deal. In the next video, we'll be talking about some other methods of raising capital through public capital markets.